Oh, this is great. Big CBD news out of Europe. A Court of Justice ruling on Kanavape was handed down in November of 2020. It's an international episode of Cannabis Legalization News. Hello, I'm Tom, a lawyer with the Collateral Base and host of Cannabis Legalization News. Like and subscribe to learn all about the policy and the evolving laws in this new industry, like today's episode, European CBD Legality. A recent ruling by the Court of Justice of the European Union, the CJEU, clarified that CBD is not a narcotic in Europe, and this is opening a new window for reform on CBD regulations in France and all over Europe. And it may force national regulators to re-examine existing restrictions related to hemp-derived products in the EU. The French Kanavape case involving two directors of Catlab SAS who were prosecuted and fined for selling Kanavape, a vape product marketed in France that contains CBD from hemp legally grown and extracted and supplied to them by the Czech Republic, another EU member nation state. This European court stated that when taking into account the purpose and general spirit of the 1961 UN Single Convention, CBD should not be considered a narcotic, as CBD does not have any psychotropic effect or any harmful effect on human health. Specifically, the court ruled that EU states cannot ban the marketing of CBD legally produced in another member state unless the risk to public health, quote, appears sufficiently established, end quote. Let's talk about the background of the Kanavape case. The Kanavape case originated with a 2014 dispute between Catlab SAS and the National Agency for the Safety of Health Products in France over the marketing of a CBD vape product whose contents were legally imported from the Czech Republic. France does not allow the marketing of products derived from the hemp flower or the entire plant. Under their public health code, whole hemp products are prohibited. Only end products from stems and seeds are permitted, and CBD produced from hemp flowers fall under the narcotics legislation, although not synthetic CBD. Par for the course for the cannabis laws. They don't even make sense in Europe, but things are improving. This case was appealed on the grounds of whether preventing the product's sale violates the European Union single market principles, since the CBD used in the products was extracted from legally grown Czech Republic hemp. The Court of Appeals in Aix-en Provence, I totally could not speak French on that, AIX-EN. I'm going to pronounce that as French Provence. Not even close. Forwarded the case to the EU Court of Justice to rule on the compatibility of French and EU law in the case. EU law establishes the free movement of goods within the Union, save for exceptions like the protections of public health. Narcotic drugs fall into this exception. Narcotic drugs, which may only be produced and traded under control for medical purposes. It should be recalled that the free movement of goods between member states is a fundamental principle of the FEU Treaty, which expressed in the prohibition of quantitative import restrictions between member states and all measures having an equivalent effect. As part of this ruling, the CJEU considered whether hemp flower-derived CBD can be considered a narcotic under the international treaty definitions, given that if it is, France may have been entitled to prohibit its sale, but that is a question for a different case. The court also stated that its decision to prohibit the marketing of products that were lawfully manufactured in another EU state decided that it can be adopted exclusively if the risk to public health can be demonstrated. And the court cited back to a 2010 precedent regarding that restrictions on that must be proven for public health. The court held a decision to prohibit marketing, which indeed constitutes the most restrictive obstacle to this trade in products lawfully manufactured and marketed in other member states, can be adopted only if the real risk alleged for public health appears sufficiently established on the basis of the latest scientific data available at the date of adoption of such decision. In such a context, the object of the risk assessment to be carried out by a member state is to apprise the degrees of possibility of harmful effects on human health from the use of the prohibited products and the seriousness of the potential effects. This is totally different than how courts work in the United States, by the way. Totally different. The court decided to interpret the matter, precluding the national legislation which prohibits the marketing of CBD lawfully produced in another member state when it's extracted from the cannabis sativa plant in its entirety and not solely from the fiber or seeds, unless that legislation is appropriate for securing the attainment of the objective of protecting public health and does not go beyond which is necessary for that purpose. The CBD ban was beyond that purpose. As the court cited, it appears to the referring court, since the level of THC in the hemp marketed lawfully in other member states is lower than 0.2%, CBD cannot be classified as a narcotic drug. Indeed, according to the judgments of 26 October 1982, only a product whose harmfulness is demonstrated or generally recognized and whose importation and marketing is prohibited in all member states may be classified as such. The decision was clear that CBD has been demonstrated to not be a harmful product, meaning that French prohibition to its marketing in the aims of protecting public health could not interfere with the Europeans' principle of free movement of goods. The ruling appears to go further than impacting the French regulations. It's possible that the ruling will encourage lawmakers to change the regulations. This ruling appears to go farther than impacting the French regulations. It's possible that the ruling will encourage lawmakers in other member states to change their regulations for the domestic cultivation and processing of hemp for CBD. More importantly, the European Union's Court of Justice rulings creates a binding interpretation of EU laws for all member states and institutions, even if they were not involved in this specific ruling, meaning that this case interpretation applies to other EU countries where hemp is grown and CBD is extracted therefrom. If you're looking to expand your CBD hemp business into Europe or source your European products from American hemp farmers, hit that like button and subscribe for more information. And visit us at Cannabis Industry Lawyer with your specific question. I'll see you next time.